Hi, I'm Chloe. Thank you for visiting our video. Find out why our team can provide you the best services for your needs. Hundreds of clients can't be wrong. Check out the following video.
Real Estate with Realtor Kashif Sohail. Welcome to Washington, America show with international multimedia journalist, multidimensional, multifaceted artist and director of Human Rights Justice Council USA, Dr. Kashif Sohail.
If rental payments are late, the landlord may take the following actions. Eviction: if full payment of rent is not received within 5 days, the landlord may file suit to have the tenant evicted. The landlord may not remove or exclude the tenant from the property or deny essential services unless a court orders eviction. Insufficient funds: if the tenant issues a check with insufficient funds, the landlord may give notice requiring payment by cash, cashier's check, or certified check within 5 days. During the period of occupancy, the landlord may adopt additional minor changes to the rules and regulations for tenants provided that such changes do not alter the terms and conditions of the lease. These minor changes include items such as guest fees at the swimming pool or guest registration at the rental office. The landlord must give reasonable written notice of minor rule changes, but the tenant need not agree for the changes to be binding. Conversely, rule changes that substantially alter the rental agreement are only valid if the tenant agrees in writing. The tenant may refuse to accept the changes and be bound only by those conditions of the original lease. However, at the expiration of the rental agreement, the tenant must either accept the changes or vacate the property. A landlord cannot release the tenant's financial information to a third party, except for the rental amount and payment records, without the tenant's written consent. However, a prospective buyer of rental property may access all tenant information without the consent of the tenant. The Act only provides a few other limited exceptions, for example, in case of emergency or when requested by law enforcement.
A tenant may, at his own expense, install security equipment. The property must be restored to its original condition upon termination of the lease if the landlord so requests. Otherwise, the tenant must provide the landlord complete operating instructions and keys for any equipment installed. The landlord must provide a certificate to the tenant that all smoke alarms are present, have been inspected, and are in good working order, no more than once every 12 months. The landlord, his employee, or an independent contractor may perform an inspection to determine such fact. The tenant may not remove or tamper with a properly functioning smoke alarm. The tenant may request to have a carbon monoxide alarm in the unit. The landlord shall install an alarm within 90 days of receiving a written request, but he can charge a reasonable fee for its cost and installation. Once installed, the tenant may not remove or tamper with a properly functioning carbon monoxide alarm. The landlord must give the tenant reasonable notice of his intent to access the property, except in the case of an emergency.
The tenant cannot deny reasonable requests so long as the landlord does not abuse the right. The tenant may seek an injunction from a circuit court barring the landlord's access where the landlord abuses his right. If a tenant plans to be absent from the property for greater than 7 days, the landlord may enter as necessary to protect the property. If the lease requires the tenant to notify the landlord of absences and the tenant fails to do so, the tenant may be responsible for any damage that occurs during his absence.
Many leases contain automatic renewal clauses that specify that the lease will automatically renew under the same terms and conditions unless either party provides written notice within a specific number of days prior to termination. These clauses are valid. However, changes such as rent increase must be agreed to by the tenant in writing. If the tenant fails to agree to changes, then she must vacate the property. In the event that all terms and conditions, including rent, remain unchanged, the renewal of the rental agreement is considered to be a new agreement. Military personnel subject to transfer may terminate a valid lease by serving the landlord a written notice at least 30 days prior to when the next rental payment is due, to be effective on a date after this notice period ends. The termination shall not be more than 60 days prior to the date of military departure.
Victims of family abuse, sexual abuse, or criminal sexual assault may terminate a valid lease by serving the landlord a written notice at least 30 days prior to when the next rental payment is due, to be effective on a date after this notice period ends. The tenant shall furnish the landlord a copy of the protection or conviction orders. No charges may be imposed by the landlord for damages. The landlord must notify the tenant within 5 days after receiving a notice of mortgage default, acceleration, or foreclosure sale from the lender. If the landlord fails to notify the tenant, they can terminate the lease by providing a 5-day written notice to the landlord. If a tenant remains and the dwelling is sold in foreclosure, that foreclosure shall act as a termination of the rental agreement with the previous owner. In such case, the tenant can remain in possession on a month-to-month basis and with the same rental terms. This shall continue until the new owner decides to terminate or enter into a new rental agreement with the tenant. If the lease allows a tenant to sublease, the landlord must approve or disapprove the sublessee within 10 days of written notification. Failure to respond within this time is equivalent to an automatic approval of the sublessee. Personal property left on the landlord's premises may become abandoned. Subleasing, also called subletting, is when a tenant rents their room or apartment out to someone else for a period of the lease. While the lease is still under the original tenant's name, the new tenant, also known as the sublessee, is responsible for paying rent and taking care of the property.
The landlord may dispose of such property provided he has given the tenant, 1. A termination notice, which states that any property left on the premises will be disposed of within 1 day after the lease ends. 2. Written notice that any property left on the premises will be disposed of within 1 day after expiration of the required 7-day lease abandonment notice period. Or, 3. A separate 10-day written notice that any property left on the premises will be disposed of within 1 day after expiration of said notice period. Any funds received from the sale of the abandoned property may be used to offset any debt owed by the tenant, including selling expenses or storage costs. Any excess funds must be treated as a security deposit.
The Landlord and Tenant Act does not apply to the following: landlord employees, maintenance persons living on site. Single-family houses, when the owner rents 2 or fewer single-family houses and has chosen to include an opt-out statement in the lease agreement. This exemption only applies to owners who are natural persons, and not artificial persons, corporations. All apartment buildings, regardless of the number owned and rented, are subject to the Landlord-Tenant Act. The Act does apply to public housing, HUD regulated.
Condominiums are a popular form of property ownership. Condominiums are multi-unit dwellings that contain areas or structures under common ownership, called common areas. However, a condominium may be a standalone, or even a single-family, unit. Whether a property is properly classified as a condominium turns on the intent and legal actions undertaken by its owners. The statute defines a condominium as real property and any incidents thereto or interest therein, with recorded, condominium instruments. No project shall be deemed a condominium unless the undivided interests in the common elements are vested in the unit owners. An owner that establishes or converts property to condominium ownership. The owner is referred to as the declarant because she must declare the intent to have the property considered a condominium.
In order to create a condominium development, the declarant must provide a declaration to the Common Interest Community Board with the following mandatory items. The name must include the word condominium. The legal description of the property. Plats and/or plans that identify each unit within the boundaries of the property. An exact description of the boundaries of each individual unit, both horizontal and vertical. The designation and description of common elements and limited common elements. In order to create a condominium development, the declarant must provide a declaration to the Common Interest Community Board with the following mandatory items. The exact allocation of the undivided ownership interest in the common elements. If the property being converted is currently leased, the names of each lessee and the date their lease expires. Any easements that exist or will be created, either to the common elements or any individual unit.
So, since you've learned more about us, click the link in the description to see how you can contact us.
Please share this video, subscribe to our channel.
Are you looking to buy or sell a home anytime soon? If so, you've come to the right place. We'd like to give you the opportunity to work with one of the top local real estate agents and get the best deal when buying or selling a home. The fact is, experienced agents can often get you a 2 to 10% better deal on the purchase or sale of a property, mostly due to their experience in the local marketplace and their ability to negotiate the best deal. So contact our top agent now and start the process of buying or selling your home.